Hi, I'm Jerry Carter with the Sierra Crest Business Law Group. We get a lot of questions from clients and others about demand letters, and they want to know, should the business send the demand letter or should we have the attorney write the demand letter? And so I want to talk in this video about some considerations for writing an effective demand letter and who it should come from. So the first consideration is, what does an effective demand letter look like? So let's just describe that. A demand letter should say who's sending the demand, who it's addressed to, and what specifically is being demanded. It should have a succinct description of the background and why the payment is owed or why the demand is being made, such that a complete stranger could pick up that letter and understand what is going on. The demand letter should conclude with a deadline and should say what will or may happen if the deadline is not met. Right? So that's the first consideration. What does the demand look like? The second consideration is who should write the demand. Ideally, if time is not an issue, I like to see the business write the first demand and usually the second demand before turning it over to an attorney. So the second consideration is, who should the demand come from? And what I like to see is, I like to see the business making the first written demand and usually the second written demand before turning it over to the attorney to write a follow-up demand. Think progressive discipline. So the third consideration is knowing that first and maybe second demand are going to come from the business and be signed by somebody in the business. When do you need an attorney to get involved in that letter? And by getting involved, that could mean that you have the attorney ghostwrite the demand for the business, or that the attorney gives input. So here's some things to think about. First, if we're talking about a form demand letter, then sure, prepare the demand letter, have the attorney look it over, because you're going to use the form over and over again. You want to make it right. Another thing to think about is there a dispute? I mean, is this just a deadbeat you're writing the demand to, or is there a live dispute about what is owed or what needs to be done? The more of a dispute you have, the more you don't want to have the business make an unnecessary admission or lock itself into an incorrect interpretation of the contract, and the more careful you want to be, and the more you would tend to want to have an attorney involved in helping with the business's demand letter. Another reason you might want to have the attorney help with the business's demand is if you just don't have time and you need to get it done. Likewise, if you want to be sure of your position, you need to know you're on solid ground, you might want to run it by an attorney. To summarize, in my opinion, if there's a lot at stake, or if it's a serious issue that you're writing a letter on, usually it makes sense to at least phone your attorney and have a conversation with the attorney about what's going on. In my opinion, if there's a significant dispute or a significant issue being addressed by the demand letter, it's usually worth it for you to call the business's attorney, tell the attorney what's going on, and get some feedback from the attorney. If making that one phone call keeps things on track, or it keeps you from making a serious mistake, then that phone call is worth thousands of dollars and potentially more. Now, of course, we at the Sierra Crest Business Law Group have a lot of experience making demands on behalf of clients and also assisting clients in making their own demands. We are happy to talk with you and answer your questions regarding a demand letter that you're preparing right now. Please give us a call. The number here is 775-448-6070, and we look forward to talking with you.